proceed.
Judge, there was a motion filed at 9:54 p.m. last night that affects the same second witness. I don't know if Your Honor wants to address it this morning, in addition to the same second motion limiting. Or you want to do it after the first witness? It's going to be fairly short.
Tell me what the issue is now.
So this stayed on Friday afternoon after Mr. Glass's deposition filed same second motion limiting. Does Your Honor have a copy of that?
I have a motion limited filed by the state. I don't know which one we're talking about. I read it. It's
I emailed it to Your Honor's JK on Friday afternoon. It's titled State Second.
yes, I've read it.
That's what Your Honor. So there are three motion limiting. The first one is regarding the defendant's essentially self-serving hearsay statements during the deposition of Mr. Glass. Counsel asked Mr. Glass whether or not the defendant had ever admitted fault, essentially in the incident. So that would be a self-serving statement that the state would seek to exclude, in addition to any other self-serving statements during cross-examination.
Anything else you want to talk about?
Yes, that was just as the point one. Second, prior bad acts. As to the witness, Mr. Glass, any prior arrests that did not result in any convictions. In addition to, counsel brought up a alleged shooting incident that was denied by the witness, and there was also allegations of him being, just generally involved in bad acts. So we would move to exclude any of those. He does have 2 prior felony convictions, so those would be what counsel's testimony should be limited to. And finally, the drug use, which I cited to Edwards versus State, which is 548 Southern 2nd, 656, Florida Supreme Court, 1989, regarding when counsel can inquire from a witness whether or not he's utilized drugs. The witnesses admitted and did admit in deposition that he did smoke weed on the date of incident. But however, counsel did inquire as to his general drug use, and so the state would seek to exclude any general drug use that's not related to either the date of the incident or, according to Edwards versus State, any other testimony that would affect his ability to recall events. And those are the state's 3 motion limitations.
Well, it's 1 motion limited, but 3 paragraphs.
Yes, 3 paragraphs, yes.
Thank you. Defense Attorney.
Good morning, Your Honor.
Good morning.
As to, I'm trying to recall, as to the issue of drug use, I'm not thinking that it's our intention to date his drug use back to birth. However, we know that one of the lasting and long-term effects of chronic marijuana usage is affects one's memory. So the fact that I think when he was asked, do you smoke marijuana? His answer was yes. And how often? The answer was whenever I can. I'm not sure that we should be limited to the date in question, because the impact of such chronic use, whenever he can get his hands on it, impacts his ability to recall matters. With respect to his prior bad acts, there are 2 felonies which are clearly our impeachment. And beyond that, however, he was charged. This is a witness who made himself deliberately unavailable to the parties for years. He then gets charged in May of this year with a crime, and now and then watches the proceedings on television and has suddenly made himself available. That goes to bias his intent.
I don't think the state was suggesting that you couldn't ask questions about whatever current charge he has. Are you suggesting that?
No, Judge, I didn't address that, because he can ask about the charges, about the maximum minimum penalties, and I would agree that he could ask whether or not he's been incurred in favor in exchange for his testimony as it relates to that.
With regard to the current charges.
Correct.
And well, if the state's position is we can't impeach him with anything beyond the current charges and his felonies, we agree. I can't remember what the first point was.
So it was self-serving hearsay statements of your client?
First of all, it's not a statement. A statement are utterances. The question that was put to the witness was whether or not Mr. Demons ever admitted involvement in the activity. The answer is no. There was a time during which the witness indicates that he was inquiring of various people what may have happened. And him saying that Mr. Demons never admitted involvement in the offense is not him uttering a hearsay statement. It's him denying the existence of any statement, hearsay or otherwise. So I don't think there's a hearsay exclusion to the failure to admit involvement in an offense. So I don't think that that question ought to be precluded if in fact we decide to put it to the witness.
Thank you. Well, regarding the first issue about the witness's alleged testimony that the defendant, Mr. Demons, didn't admit to him that he was involved in it, that's not something the witness observed or anything. That's in essence an exculpatory statement. I agree with the state. You can't do that. I agree that regarding the prior bad acts and impeachment, we're all on the same page. You can ask about whatever the pending charge is. You can talk about that in the prior 2 felons. But as to other uncharged offenses that may have happened along the way, those are not. Can't inquire as to those. As far as the drug use, if he's using marijuana, cannabis at the time, that's all fair game. I don't see any issue with that. And if he uses it frequently, I don't see any issue with that either. I don't know that that's the type of. It may have been at one time the type of drug use that was concerned, but it's staying in your system for a while, it has effects on you. I think all that's fair game. I don't have any issue with it. And I understand Edwards talks about when you're under the influence of something, but if it's over a period of time, I've heard from various experts how long it stays in the system and how long it can do it. So it can be for a period of time.
Okay, and just to clarify, Your Honor's ruling, period of time meaning from the date of incident to current date, or even predating the date of incident?
Counsel, to me, it's fair game. They can go into it.
Okay, I just wanted to
I don't have
clarify.
any issue with it. All right.
And Judge, the defense did file a motion to exclude Trevion Glass from testifying at all. I don't know if they want to or Your Honor wants to address it at this time.
We can address it at this time.
Sure, go ahead.
Did you have a chance to read my motion and the case law this morning?
I did.
All right.
Thank you.
So it's basic, as I stated in my motion. After 4 years, we're finally able to depose Mr. Trevion Glass. Interesting enough, as I set forth in my motion, and I attached the pages of his transcript, he states that it wasn't until he started watching YouTube, because this case was live streaming, and hearing his name repeated everywhere, that he decided to call up the prosecution. As I further stated in the deposition, specifically questions were asked about his independent recollection of this incident, and he clearly states, let me go to it, I wasn't aware who got into what seat that day, but from me watching what's going on, yeah, I know now, yeah. Mr. Howard then clarified that. Watching what's going on, do you mean the trial proceedings? He said, correct. Looking at this rule of sequestration, and we know it here as the rule dates back to biblical times. And going back into them, it's been well established that we need these protections of this rule of sequestration to prevent witnesses tailoring their testimony to match the testimony of the previous witnesses. And that's exactly what we have here. 2023, In the Bible, they didn't have a TV live streaming into the courtroom. So most of our rules, when we were dealing with it, are saying, you cannot sit in this gallery and then come up on this stand and testify. But if he's sitting there watching from that TV, from the comfort of his home, there is no difference from him sitting here in this gallery and then getting up there and testifying. That is the crux of this rule, and that is exactly what it is meant to prevent. Sequestrations of witnesses is one of the oldest and most time-honored rules in the court system. It's to ensure that we have effective truth-seeking. And we won't have effective truth-seeking if he's allowed to sit here, watch everybody testify, and get up there and then tailor his testimony to the last 3 weeks of evidence and other witnesses who have testified. I've provided the case law. I think the law is clear. Reading into that case law, because this rule of sequestration, we do have a sister rule in the federal court system, 615. And they've actually gone on a little bit further with their cases to give us examples of out-of-courtroom communications that are not allowed. And they give us examples of witnesses sitting outside of the courtroom talking about what they testified with another witness who's going to testify. They talk about giving witnesses the transcripts of other witnesses and preventing them from testifying. In this case, again, he watched the entire trial. We don't even have to guess about this because he tells us in his own deposition that he's been watching this trial, that he's heard his name in this trial, and that's why he's decided after 4 years to come and testify. He must be excluded to guarantee my client a right to fair trial.
Thank you. What's this state?
And as you know, exclusion of a witness is the harshest sanction that this court can impose. The state acknowledges there was a violation of the rule of sequestration. The witness indicated so in the deposition. However, counsel's representation that he watched the entire trial is wholly inaccurate. That's not what his testimony was. So the court must determine whether or not it was an intentional violation, whether it was inadvertent, or whether it was any bad faith on part of the witness or the state here in particular. The state would proffer that it was an inadvertent violation. It was unintentional on part of the state. As your honor is well aware, it's been documented that Mr. Glass has not been cooperative with the state. We tried to subpoena him pre-trial. In fact, the first time the state spoke with Mr. Glass was after his current arrest, which I believe was in June of 2023. The state contacted the witness for the first time and was able to speak with him after we had already began trial testimony. The witness indicated to me that he would not be here, he would not come, and he would not cooperate with the state subpoena. He did corroborate that in his deposition, that he did in fact inform me of that information. And therefore the state operated as he was not going to testify. It was not until the defense subpoenaed the witness that he became compliant and came in on Friday. I think the first time he came to Broward County and the state met with him was on Thursday of last week, which I believe was July 6th. So the first time the state would actually had an opportunity to even speak with the witness in person and inform him of the repercussions of the rule of sequestration was well after testimony had begun already. And the prejudice that the defense has cited in their motion is essentially that he's watched the video surveillance, which is currently in evidence at stage 7, and has changed his testimony based on his review of the video surveillance. So 2 things. He did give a statement to Detective Moretti back on February 26th of 2019, and he indicated that he got into the backseat of the red Mitsubishi. He's now been refreshed, and his memory is now refreshed that he did in fact get into the front seat and not the back passenger seat of that red Mitsubishi. The state would proffer that that prejudice is minimal, and the reason is because we have video surveillance. And so Mr. Glass, in and of himself, can be impeached based on his prior testimony saying he got into the back seat versus the front seat. And that's the only prejudice that the defense has outlined in his deposition testimony that has been colored by his view of any of the trial testimony. And so based on that information, one moment, Judge. The state would say that rule of sequestration for this court to exclude him completely as a witness would not serve its purpose. It's not a per se rule to exclude. The trial court has discretion, and I would ask you to exercise your discretion because there's less intrusive means, being one of him being impeached based on the inconsistency itself.
You have the transcript of this witness's
I
testimony?
ordered a copy and we did not receive
I
one.
do have the transcript, Judge.
If counsel can be so kind as to also provide us with a copy, we haven't received our copy.
Any problem with that?
No, I can email it right now.
All right, so could you give a copy of that to Travis?
Yes.
And what I'll do is I'll make it, well, I don't know if I'm allowed to make copies.
I can email to Ingrid, and then I can email to them. They have their copy machine right there. I do
Great.
have one quick follow-up, Judge, if I may.
Sure.
So there is a line of cases, and counsel is arguing from the line of cases where the defense has violated the rule of sequestration. So when it's a defendant violating the rule of sequestration, you do have to go into a Sixth Amendment analysis because it's his constitutional rights that the court still has to protect. And that's why you have that stringent standard. However, when you're dealing with the prosecution violating the rule of sequestration, then it becomes the question of my client's rights to a fair trial, and that's how the analysis should go. And you're looking at those line of questions when you go to 96.16, there is another section that comes down that gives exceptions to the rule of sequestration, which we see. We have the witness's family in here. Why are they allowed in here? Because of 96.16 gives that exception. But there's case law that says when that family gets up there to testify, Mr. Demons' client rights to a fair trial will trump the other people's rights in this case. In this matter, Mr. Glass doesn't have any rights to be in this courtroom. He has no right to be watching this from TV. His testimony to the evidence. I would ask that we look at this in the light most favorable to Mr. Demons and his constitutional right to a fair trial. And that's what we want today. And it's not going to happen with a witness who's been watching this proceeding from the comfort of his home.
But the defense isn't suggesting that this was all some type of connivance with the state, that they planned this or executed in some fashion to get around the rule of sequestration. You're not suggesting that. You're suggesting that he shouldn't be allowed to testify because it's a violation of the rule, which the state's agreeing it's a violation because the rule of sequestration was involved. But you're not alleging or suggesting the state had anything to do with it, are you?
So, Judge, and I did ponder this last night, and for the sake of being a professional, I did not come with a motion for prosecutorial misconduct. But as we've heard Ms. Smith admit herself that she sat in that deposition with us, and they too realized that he had been watching the trial from his own testimony. The simple fact that the state now wants to even put him on the stand is knowingly, Judge. They knew in the deposition, 1. 2, they knew when I put him on notice with my motion. So they had the opportunity after the deposition, 2, after my motion pointing out we violated the rule of sequestration, just not to call them. They, however, are going to continue to proceed knowing he has violated the rule and put him on the stand. So, yes, when we look at it that way, the state may be acting inappropriately.
Thank you. And counsel, from your perspective, as far as the state's concerned, once you found out this witness was going to, his location was found, and you gave his address over, and I know you said he wasn't going to cooperate. I think you made that representation in open court a week or so ago as well. I don't know the exact date, but you made a representation to that effect. When was the first time that you advised the witness that the rule of sequestration was invoked?
Judge, last Thursday, because prior to that, I had only spoken to him on the phone, and he had told me we essentially had abandoned almost calling him as a witness absent a decision to do a rule to show cause, which we had not decided at that point. So when he told me he wasn't coming in, I had no further conversation with him until he contacted our office, and that was in response to the deposition. And council's essentially...
What date was that?
I can have council look up the exact date to let you know, because we have an email when we contacted our office.
That's the time that you told him the rule was invoked?
No. He called our office indicating that he had gotten a subpoena and whether or not he needed to appear, which we indicated, yes, he did need to comply with the subpoena. We tried to make arrangements for him to come. I believe his deposition was scheduled on a Tuesday, if I'm not mistaken.
No, that was the deposition that was set, Your Honor, if you recall, without any discussion or scheduling with the state for that Friday.
So it was set on a particular date, and he failed to appear that day. And then I called him when he failed to appear while defense was still in state attorney's office in the lobby. I said, "Are you in Broward County right now?" He said, "No, I'm not. I don't have a ride." I said, "Okay, if transportation is arranged, can you make yourself available?" He said he would. He called us. He told us he would be in Broward County, I think, Thursday afternoon. He called us on Thursday, said he was in Broward County, and that was the first time we met with him in person. And I would say, Judge, the defense is asking you to essentially apply a per se rule. The case law says there's no per se exclusion for the rule of sequestration. The only thing she's saying that's been affected is his seat position in the Mitsubishi car. That seat position is on video. It's in state 7. And so that's something that the state can even show the witness in preparation for his testimony. It's something we would publish during his testimony. So that contradiction between where he sat in the car is not of the sort that should exclude his entire testimony and would color his testimony.
Thank you. My question, though, as to when you first advised the witness?
Thursday, Judge, when we met with him in person.
Last Thursday.
Yes, Judge, when we met with him in person for the first time.
Thank you. All right, I'm going to defer ruling on it. Just, I'd like to read the transcript.
Your Honor, I think the case law is also clear that you need to read his initial statement to see if there's been any change in his statement from the initial statement to the deposition.
And I'm going to provide, if I can approach, Your Honor.
Where's the case law? I thought you were having the case law.
I'm providing the statement so I can provide it to the judge.
I have the statement. I want to see the case law you're quoting to, because we're talking about excluding him. I didn't see any case law. It says
I only
substantial.
just cited it in case of counsel. They just cited the rule. But let's do this, though. I'm not done with this yet. I want to read what he said as well as the statement. I want to take a look at those things.
May I approach, Your Honor?
Sure.
And so the
Who's your
case,
next witness, by the way?
It's Jamell Demons. He's a records custodian, so we anticipate it's going to take about 5 minutes, which is why we...
Where's your next witness after that?
Mr. Glass.
Where's this Detective Moretti?
He's also
He's
going
in
to
the
be
meeting,
this
right?
afternoon.
and Judge, I'm going to print out the copy of the case law that the state was citing to, which I'll print out a copy for counsel and for Your Honor.
She's got her notes on. I don't want that because you have your notes on there. So I'm not.
So I'll take this. It's just the last.
That's all right. Can you just email it?
I'll do it right now, Judge.
Thank you. She'll print it out. I would like to read it. And we'll just have it marked as a court exhibit for the purpose of this. So.
State's otherwise ready, Your Honor, to proceed with the first one.
Who is the first one?
Dan Demons, records custodian for Montessori School.
And Judge, we do need to do one quick order to keep State 64 under seal for the purposes of the clerk. There is sexually explicit photos of minors and videos on there, so that has to be, the clerk needs to be made aware of that on the 9807. Mr. Demons, Mr. Demons.
Any objection?
No objections.
All right, go ahead and sign. I'll sign it. Thank you. All right, you're all set, ready to proceed?
Yes, Your Honor.
Defense?
Yes, sir.
All right, let's bring the jury.